Okay, call to order. First item of business, pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First, we have a little bit of a administrative requirement that we have to administer the oath of office to both Karen Hall and David Tucker. Kimberly's going to ask you to come up with it on the podium there. Do that.
All right, so we'll do your name, okay?
Okay.
I,
David Tucker,
Karen Hall, do solemnly swear
do solemnly swear
that I will support and maintain
that I will support and maintain
the Constitution and laws
the Constitution and laws
of the United States
of the United States
and the Constitution and laws
and the Constitution and laws
of North Carolina,
of North Carolina,
not inconsistent therewith,
not inconsistent therewith,
and that I will
and that I will
faithfully discharge the duties
faithfully discharge the duties
of my office
as a member
of the Board of Adjustment.
of the Board of Adjustment.
So help me God.
So help me God.
Thank you.
Thank you.
Yeah, welcome aboard. So next we have to check for a conflict of interest. If anybody has any conflict of interest concerning either of these cases that are here today, I'll ask.
No.
Jay, David?
Nope.
None. Bruce, Karen? And I do not either. Okay, then we have a minutes to, agenda, sorry, I should look at the agenda. Does anybody have anything they want to do to the agenda, amend it, approve it? Let's go. Any amendments up here that you know of? No? Okay. Motion to approve the agenda?
I move to approve the agenda.
Second.
And all in favor of that?
Aye.
Self as well? Okay. So first we have minutes from the last meeting back in February. And I have a couple of comments about them that I wanted to make before we approve them. If it's okay with you folks. On the first page under 5.1, there's a section that has Hershaw started to talk. And it's written in the past tense, and it really should be written in the present tense. Instead of was, it should be this is a case. Okay, so if you would just make that in the present tense, we'll be happy.
Mhm.
And I think it happens again in the bottom of the page, Satterfield, where he's saying it, and before you is an application rather than was an application. All right, and you'll see was a couple times in there. That should be is. Put it in the present tense. Okay, and then I also have a comment on page 4, where down near the bottom of the page, fourth from last, Bornham, where I was speaking, and it says, I was trying to say, moving the proposed, I guess, patio and roof, moving it would provide a greater setback and avoid conflict. And that would eliminate the need for a variance, basically. Okay. Okay, that's other than that. If anybody else has any comments? No comments from you folks, and motion to approve, somebody?
I move to approve.
Second.
Okay, David, approve?
Approved.
Approve, you in favor? I'm in favor? Okay, they're approved. All right. Okay, so we move on to new business. First before us, an application 2025-01. And I think I would first ask our planning consultant, Wes, and I guess you should be sworn in if you're going to testify.
Well, yes. Everybody do that? Yeah. Yes, yes, sir. And I guess perhaps everyone that's intending to testify could all be sworn in at once.
I agree with that. I was just going to ask Jerry, typically we swear in applicants and their consultants. I'm not sure about attorneys.
I'm not an attorney.
I realize that.
They're not attorneys.
It looks like we have a few here.
But anyone else that's intending
You don't
to
normally
provide
swear as
testimony.
attorneys. That's what I thought.
Attorneys, we're arguing on testifying. Are not.
Correct. You're not testifying. That's what I thought.
But yes, I'm happy to be sworn in addition to anyone else that's interested.
Kimberly, you take care of that? Anybody out there in the audience who wants to possibly testify?
Other matters.
Second case.
Mr. Jeanette as well, second.
We can wait till you guys, we'll wait on it.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Lisa will be testifying as well.
She may.
Okay.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So
Yeah.
help you God?
Yes.
Thank
All right, so first, I guess we're going to hear from our planning consultant about summarizing the case in this report that we have. And then the report will be entered into the record as evidence. And then I'll turn it over to our attorney over here. Jerry, you're going to think what the next steps would be relative to our application. Okay, Wes.
Thank you, Mr. Chair. Thank you, Board. Wes McLeod. I'm planning consultant for the town here. I'll just provide a brief overview as I trust you all have been able to read this, and I'm certainly happy to answer any questions from the staff report standpoint. For you is an appeal of an administrative decision based upon a determination that the proposed improvements to town-owned property located at the west of the intersection of 40th Street and West Main Street do not require UDO approval, including site plan approval, and that the improvements do not constitute development as defined in Section 7.3 of the town's UDO. Subject property is identified as Brunswick County Parcel ID 263HA001. It's located at the intersection of 40th Street and West Main Street and is approximately 0.21 acres. Just briefly, the property was deeded to the town of Sunset Beach by Sunset Beach West LLC on November 5th, 2019. There is an aerial photo included on packet page 9. Based on historical aerial photography, it appears that the area has been used for parking for more than 25 years. There is a timeline that is included in your staff report. I'm not going to go through this in detail, but you can see the series of events that led us to here today. And then there's also reference to applicable sections of the UDO, including approval procedures for minor site plans and major site plans. And then there is a definition of development and parking lot also included in the staff report. And then there are, beginning on page 3, facts that are relevant to the UDO administrator's interpretation and decision that is being appealed to this board. The staff report includes 9 different attachments, including the appeal letter from the applicant, emails from the applicant, letter from the applicant requesting the administrative determination or interpretation. There is the official determination issued by the UDO administrator that is being appealed, including in that attachment. There are the parking standards, and then there's also a site plan, although it is a bit difficult to read, included in there. The West End parking area refurbishing plan, including as attachment 7. And then lastly, plats of the subject property and an aerial photography for Brunswick County GIS. I'll just remind you all of, and certainly your council here, of the appeal standards are included in the staff report beginning on page 4, and that is from UDO section 2.14, subsection E. Mr. Chair, I'm happy to answer any particular questions about the staff report. Otherwise, I'll turn it over to you and the board.
Okay. I'd like to confirm the one dimension that I see on here from the, well, first, the parking spaces, are they shown on this plan that you gave us at 9 by 18?
Yes, sir. I believe that's the case. We would need to confirm that. However, I don't see dimensional standards on here.
Then the question is that, looks like,
They may be wider. In fact, 9 by 20.
okay, and there's a dimension from the end of the parking spaces to this piece of, looks like a property line,
Yes, sir. That is shown there as 29.2.
29.2 feet.
Yes, sir.
Okay. A little difficult to read that one.
Yes, it is.
And the parking spaces may actually be 20 feet long as opposed to 18.
I don't know. Sorry. They are shown here. If you see, there's a notation on there.
Yes.
9 by 18 parking space typical. It's, again, difficult to see. I've got an 11 by 17 copy here.
Okay. Well, 9 by 18 is what the ordinance requires, right?
Yes, sir.
Okay.
That's correct.
All right. Thanks.
Mr. Chairman, members of the board, good morning. I'm Grady Richardson. I represent the town staff and town attorney for Sunset Beach. We would move all of the staff report into the record as an entire Exhibit 1.
Okay. I support that. You need to do anything about that? Okay. No objections. Good. So moved. Debating whether to ask this question now or wait till later, but should I ask the town attorney or you, Jerry, why is this case before the Board of Adjustment versus the council? No, I recognize that it's an appeal of a decision, but boards regardless. Okay. All right. After this hearing is over, can the applicant go to the council or if they choose to? It's okay. After this hearing is over, does the applicant have the right to go somewhere else if they don't like the end result of the hearing?
Yes, they have further relief, but it's going to be to the Superior Court.
Superior Court versus the council? Okay. Just needed to know that. All right. Jerry, I'm ready for the applicant to proceed with their case if you would like to do that.
Thank you, Chairman and members of the board. My name is Jeffrey Rother. I'm an attorney at Morningstar Law Group, here representing Fairline Investors LLC, which is the appellant for this matter. I'm here today with my colleague Hunter Winstead and Ron and Nancy McFarland, who are the members of Fairline Investors. Thank you for the board's time and attention today. We very much do appreciate the attention to this matter. Fairline Investors is the owner of the property at 1405 West Main Street here in Sunset Beach, which is a residential property. It's the last home on the westernmost end of Main Street, and has access to the roadway network through a single driveway at the very end of Main Street to the right of way there. There's an aerial photograph in the staff report, which is now in evidence. This matter relates to the parcel of land owned by the town that's directly to the north, which lies to the west of the intersection of West Main Street and 40th. Up until this year, there was parallel parking available to the public within the shoulder of Main Street. That can be seen in the photographs in the record as well. This spring, Fairlane learned of a plan by the town to effectively close one half of the right-of-way to traffic to be able to reconfigure the parallel parking to allow for the addition of 14 perpendicular parking spaces at the end of Main Street. This is all directly outside of Fairlane's property and the neighboring properties. Fairlane began asking questions, including whether the plan had been reviewed by the professionals under applicable standards and make sure it meets town code. Some of the very same questions that Chairman that you were asking, trying to look at that plan, right? And no clear answers were being provided. So that takes us to why we're here today, and I'm happy to address some of those questions. I'm going to give a brief overview for why we're here, and then we'll start getting into the evidence. Fairlane believed that there needed to be a review of this parking plan under town standards and started asking whether it had been done, whether it had been approved, whether there was a site plan approved under the UDO. There was nothing forthcoming. So it submitted a request for interpretation, and that's now in the record as part of the agenda packet. That was on March 25th, and asked for determinations under the procedures allowed under the UDO, determining that the plan reflected a parking lot, needed to be reviewed under the UDO under applicable standards, and also asked for a determination that the plan in fact didn't meet those UDO standards, including that the plan provides for parking that allows someone to back up into the right of way. In response to that, we received a written interpretation from Ms. Englund under the procedures in the UDO, and she disagreed. And that's, again, in the record, her position that there was no UDO or site plan review required for this parking lot configuration because the improvements do not constitute development under the UDO. And alternatively, they took the position that the town is not subject to its own development code with regard to matters like these for parking because of a state statute, which is 160D-913. On behalf of Fairlane, my law firm appealed that written interpretation, took the position that the town and Ms. Englund are misreading the ordinance, that this is development, needs to be reviewed under the UDO, and also took the position that the town was erring and relying on state law to argue that the UDO doesn't apply in these circumstances. So, and I think this goes to the chair's point, why are we here today, right? There's the questions that need to be determined today, and there's some questions that aren't being determined today. What's not involved in this hearing is paid public parking a good idea? How long has this been area available for parking? Are there better options or better configurations? Those types of policy considerations, that's not why we're here. What we're here for is an application of fact to local ordinance. Is the town required to play by its own rules with regard to this parking configuration, or can it do whatever it wants with regard to parking? This board is sitting in a quasi-judicial capacity. So it's not a court, but it's acting like a court. It takes evidence from the parties, and it applies facts to the standards set forth in the local ordinance to make a determination. And in this case, you'll hear some evidence. This is mostly an issue of ordinance interpretation as much as it is a dispute of fact. But we will have some evidence to put in, and at the very end, we will talk about the ordinance standards that apply here. So what I'd like to do, and council spoke outside before we started, I'm going to put in some evidence that bears on this issue. I'll be calling Ms. Nancy McFarland to go over with some testimony. We have some materials to provide. I believe after that, Mr. Richardson will have the opportunity to put in any other evidence that he thinks he may need, at which point the lawyers will come back up and address the ordinance standards and how we think the result in this case should turn out. So I'm happy to answer any questions the board may have at the outset. I'll certainly get into the legal standards at the end. But if there's any questions about procedure or why we're here, I'm happy to address it. If not, I will proceed with some housekeeping and putting in evidence and calling a Ms. McFarland.
Were you sworn in? Okay.
Yes, sir.
All right, I missed that.
I have a question.
Yes, sir.
You said there was no review of the parking plan. I'm looking at a drawing right here, C101, that has an engineer seal on it.
Okay.
That indicates, this is not the original, so it doesn't have to be signed, but that indicates to me that somebody reviewed it because they prepared it.
Yeah, and that's right. What the distinction that I'm bringing here is that typically with a development, that a private party who wants to do something with their property will hire their own engineers, consultants. Town, it appears from this document, hired somebody to come up with a parking configuration. But once the property owner decides what it wants to do with its property, the next step is to submit it to the town for the town's own staff to be applying the town standards to the plan to determine whether that plan meets town standards or not. So it may have been reviewed by professionals in the context of preparation. Mr. Richardson can certainly talk about who they may have hired. But what we are asking for and what we believe is required is the town to determine that the plan meets its own ordinances in the same way as any other private developer would have to submit its own plans to the town for the same review.
Doesn't work for me. I'm a professional engineer, and usually the client tells you what he wants and reviews the drawing before he seals it. So I'm not understanding how you can claim that the town has no involvement when they hired the engineer and they commissioned him to do work.
So what the town stated, sir, in the interpretation is that it does not need to comply with its own ordinances.
That's a different issue.
Yeah, that's why we're here. So I want to make sure that we're on the same page. You're saying you're a professional engineer. Yeah, the client certainly determines what it wants to do. It makes a proposal, right? That's why I said what we're not here for today is arguing that the town should want to pursue different orientation. It's not about trying to dictate what's out there. The issue before you is, does the town need to go through the same ordinance review procedures? Does it have to follow the same rules as every other landowner?
But your premise is that it's a development, so you're jumping ahead. Your one statement was that it wasn't reviewed and properly done by the town. I don't see that as correct. Now, the other issue was that may be required if, in fact, I accept that it's a development.
Well, sir, I would respectfully encourage you to listen to the evidence before you reach any conclusions as to how this matter should, what the outcome of the matter should be.
No, I'm asking you to clarify.
You're exactly right. One of the issues to be determined in this appeal is what is development, right? That is one of the triggering issues. If it's development, I think the town would concede that it needs to go through the review process.
Correct.
So I think we're on the same page, and it's not a matter of us trying to determine what the plan should be. This is an issue of whether does the town play by the same rules? Is this development, or is it something else?
I think I have several questions as well, but I'll wait to hear the testimony, or excuse me, the arguments by the attorneys, and we'll go from there.
Thank you, Mr. Chairman. So as far as housekeeping, I understand the staff report is already into evidence. I'm going to hand up binders to
Everybody.
exactly. Thank you, Hunter, and one for the clerk.
Yep. You're going to explain what's in here.
What's that? No, just. So I'm going to ask for a couple things at this point. One, that the board take notice of its UDO. I would like to make sure that the UDO is a part of today's proceedings. I printed out a single copy of the entire ordinance from the town's website. Happy to give it to the clerk of today's proceedings to make sure it's in the record. What we've done for convenience of the board is behind tab 11 of that binder, and you don't need to look at it now. We'll get into it. Are some of the provisions of the UDO that we believe are relevant to today's proceedings. The town and the staff report certainly covered many of them, but there were others that we thought were pertinent, so we put them behind tab 11. Tab 1 through 10 are materials that Ms. McFarland will go over. We'll be asking that those be submitted into evidence. So unless there's any other questions, I think the board for its time today, I'm going to call Ms. Nancy McFarland to testify and to address the exhibits that are before you. Thank you.
Okay.
Good morning, Mr. Chairman and members of the board. Thank you for your time today. My name is Nancy McFarland. My husband, Ron McFarland, and I are members of Fairlane Investors LLC. And Fairlane Investors LLC is the owner of the property located at 1405 West Main Street in Sunset Beach. We acquired the property in April of 2020 and have owned it continuously since then. Tab 1 in your notebook is a copy of the deed through which Fairlane acquired the property.
Mr. Chairman, I have to enter an objection. The way I understand quasi-judicial settings to work is there's to be questions asked of the witness because depending on those questions, I may have an objection and wish to be heard on it. I don't know whether that'll be the case or not, but for Ms. McFarland to give a narrative without questions being asked of her counsel, I have an objection to that because I have no idea what she's going to say. And once she says it, the toothpaste is out of the tube before I have the opportunity to object or move to strike.
Okay. I'm not sure I understand fully what you're saying, but I'm going to ask questions of the testimony.
She's a witness.
Correct.
And her counsel should be asking her questions for her to answer.
All right. I got you. Yes.
Respectfully, the climate consultant just gave his narrative without any direct examination. I'm not sure why we have two different standards. Every quasi-judicial meeting that I've been involved with, we're not in a courtroom. We're not subject to the rules of evidence. He has the opportunity to cross-examine.
Well, I've been doing this for 27 years, and the staff report was a summary report that counsel was provided in advance of this hearing. If he had any objections to the contents of it, he certainly could have made those objections and made a motion to strike, neither of which occurred. Evidence rules are loosened in this context, but they're not to be completely ignored either. From a due process standpoint, I have no idea what Ms. McFarland is going to say, and she should have to answer questions by her counsel to put on her burden and for me to be able to protect the town staff interest.
So to handle that, you're suggesting that the attorney that we just heard from take the binder and basically go tab by tab and ask what's in it.
No, I'm asking for the counsel to ask his witness questions that he believes is necessary to put forward their appeal before this board and to make out their case. Whether that constitutes him going through tab by tab or somehow getting to that information in a more summary fashion, more expedited fashion, that's up to him. That's his job. My job is to sit there and listen to the questions and to protect the town's interest.
Like I say, I can't overrule my attorney, but I would like to hear what's in these tabs.
So we were going to be plain and concise. It's to expedite the proceedings. Mr. Mann, this is how every quasi-judicial hearing I've ever been involved in takes place. I think there's no provision within 160D that requires direct examination as if we're in a courtroom. We're not subject to the rules of evidence. She's providing the testimony in the same way as any other party who would
Or if you had
request
asked them to.
testimony.
Yeah. All right. Well, I'd like to hear what's in this binder that's going to be submitted. This is your evidence, basically, right? That you're submitting. And to accept that, I got to hear what it is. So,
Okay, I'll be quick.
In response to questions about it, because I have no idea what she's getting ready to say. But I'll stand down. I just renew my objection. I don't think it's the appropriate way to handle the procedure on this hearing. Like Mr. Rother, I have been involved in countless quasi-judicial settings, and it's never happened where a witness gets up there and gives a narrative without answering questions from their counsel.
Please proceed.
Okay. Tab 2,
Do we have a ruling on the objection?
well, that was required. Or can I just say, I'd like to hear what she has to say? And,
You can
it's-
you can sustain
overrule
or
the
overrule the objection.
oh, geez, that's always a great thing to do.
So if you want to hear, if what I hear you saying, if you want to hear then you would overrule the.
Okay. Okay. All right. Well, I'm not sure this is, but I would think that our attorney, the applicant's attorney, could just ask her what's in the book, and she could say what's in the book.
Can we move with that?
So why don't we just go ahead with that,
Yeah.
and then hopefully is that okay?
Fairly
Please.
simple.
Ms. McFarland, can you please walk through the binder of materials and tell us what's in there?
yes, thank you. I've already referenced tab 1. Tab 2 is a copy of the same aerial photograph that was included in the agenda hearings
Right.
materials for this hearing.
Okay.
It shows the Fairlane property before the town changed the parking configuration. Our property is in the bottom left-hand side of the photograph. The area to the west of the intersection of 40th and West Main Street, labeled as parcel 263HA001, serves as the only street access to and from the property. So as you can see on the photograph, until this year, there were 5 parallel parking spaces on the north side of the street, 1 handicap space on the south side. Also, as you can see in the photograph, the parallel parking spaces were located off to the side of the travel lanes on West Main Street. So vehicles could easily drive in and out of the area even when the spaces were occupied. So tab 3 contains some additional photographs from the ground level. These were taken from Google Maps, and they accurately show the parking configuration up until this year. The first picture faces west, and you can see the Fairlane property there on the left and at the end of the street. The second picture faces east, and you can see the parallel parking and the travel lanes on Main Street as they were before. Tab 4 of the notebook is the parking plan that we received earlier this year. It is the same document that was included in attachment 7 of the meeting agenda. It became clear that the town was going to move forward with this new parking plan, but there was no indication as to whether the plan was designed by appropriate professionals or whether the town had even reviewed whether the plan satisfies its own code requirements. At the end of March 2025, the town worked on the area and reconfigured the parking alignment to reflect what is shown on the plan. Tab 5 of the binder contains photographs taken on Main Street showing that the road was closed to traffic for this work to take place. You can see that there was seal coating resurfacing applied to the area. They then installed parking blocks, installed new signs, and striped the area to allow for perpendicular parking. Tab 6 of the binder is a document I obtained from the town reflecting the work paid for by the town to implement the parking reconfiguration. The new perpendicular parking area is all paid parking. In tab 7 of the binder is a printout from the town's website about paid parking program and the rates being charged. The new parking configuration has been a problem since it was initiated earlier this year. I've personally observed the area is frequently congested with traffic and that our driveway is blocked. My observations is that drivers cannot see whether there are any available parking spots when entering the area. When the lot is full, drivers continue to enter the area looking for an available parking space until they reach the end of what is now a one-lane road. When they reach the end of the road, they are faced with the option of either one, driving a substantial distance in reverse to exit the area, which is hard because there's usually cars behind them, or two, attempting to execute a multi-point turn with very little space to complete it. And when there are enough cars in the area looking for parking, you end up with a logjam. Tab 8 of the binder reflects photographs of the conditions outside of our property on April 19th. Tab 9 of the binders reflects photographs of the conditions outside of our property on May 21st. And tab 10 of the binder reflects photographs of the conditions outside our property on July 18th. The new parking alignment also has affected access to my property by visitors and service providers. We cannot get mail delivered to our property. The mail truck says they cannot turn around, they will not deliver mail. Sometimes we get trash collected. Usually we have to follow the truck around the island and ask them to come back. Contractors were blocked from the property when the road was closed. Otherwise, they have to struggle to access because there's only one lane. If you're having any kind of even landscaping and they've got a trailer or a delivery truck or anything, there isn't room for them to make that swing to get into the driveway anymore. So I just want to mention that, you know, what this hearing is about is conformity with the UDO. And I understand that developing a UDO is hard work. So why do we do it? We do it for a couple reasons. One is to provide predictability. Citizens want to know the rules of what can be built around them. Developers want to know the rules so they can plan accordingly. But second is to provide a safe framework for development, because public safety really is our primary concern. We can see that in the UDO ordinances here that call for no parking that causes a vehicle to back into the flow of traffic. I believe that the citizen...
Mr. Chairman and Mr. Mannon, I object to Ms. McFarland testifying about what she considers the UDO policies to be about, predictability, or a safe framework. This appeal is about the zoning determination that the parking lot restriping and re-asphalting a parking lot and changing it from 6 parallel parking spaces to 6 perpendicular spaces, whether or not that constitutes a development that has to go under site plan review of the town's UDO or not. It's not about what she believes as a policy consideration a UDO is meant to serve. I've heard nothing about any criteria or qualifications of Ms. McFarland, whether she's ever even had any zoning training experience as a town manager, a town administrator, or otherwise. And so,
Sustained.
thank you.
Just for the record, I was the mayor of Raleigh for 8 years, so I have a little bit of training with UDO.
This again is the
quasi-judicial
problem.
hearings, And zoning. I do know
Yeah, I understand.
Okay.
what a UDO is.
All right, so you're...
So I guess you can take all of that and just narrow that down to the last thing that I said, which is that the UDO specifically says you shall not create parking situations that cause a vehicle to back into the flow of traffic. And that's what this does.
Fine.
That again, I would move to strike. This is the problem with not having questions asked that I can object to. I move to strike that testimony because that is not an issue before this board today. It's about the appeal of the zoning determination that this did not undergo site plan review and approval because they claim it's a development, and the zoning has, Ms. England has made the determination that it's not a development that comes under site plan review.
Okay.
Have you personally observed part of the perpendicular parking configuration backing into the right of way?
Yes.
Microphone for
I'll
him.
ask it again.
All right.
Sure.
Go ahead. Ask it.
Ms. McFarland, have you personally observed a car backing out of a parking space in the town's property?
Objection.
Into the right.
Yes.
Objection. That question is not before this board. Mr. Rother started off by saying that this is not board policy. This is not, let me use a quote, that this hearing is not about policy considerations before this board. It's about, what he said was, it's about whether or not the improvement by the town is or is not a development, and whether or not the UDO does or does not apply to what the town did.
And one of those UDO requirements is that cars not back into the right. So it's certainly pertinent as to whether the town is undergoing activities in this property that are in direct violation.
That issue,
Still is not part of the question, though. The question is, as he said, is the termination by the township administrator appropriate or not? What I'm thinking.
I requested the determination be made that it doesn't meet UDO standards, and she declined to make that interpretation. She said that we don't need to follow these rules. So I think it's certainly pertinent to know that when the town's putting its head in the sand, that there is direct violations of the UDO ongoing today.
All right. Well, first I would ask you a couple of questions. You have one here? Go ahead. Joe.
may I respond to that? In the applicant's appeal, there's nothing that says that there was something that they had asked for determination on that had not been addressed by Ms. England's determination.
Mr. Chairman, he can make his case at his part of the case. This is
Yeah.
a presentation.
Presentation. Well, then let's finish with the presentation. We've got some testimony. I'd like to hear some questions about the testimony. Do you have a question you were just about to do?
Well, it's about this whole issue of determination or of development, but I'll let her testify.
Okay, that might be a legal question as opposed to something for the
It's a
testimony.
definitional question.
Yeah, you can't ask this witness, I don't think, for that. But I could ask her. You get no mail delivery whatsoever at your house.
They will not. They say they cannot turn the truck around. We went to the post office and asked, and they said, no, we can't turn the truck around.
Let a mail delivery.
Oh, so that means I also can't get delivery
So
from
the trash
anything.
trucks. you
Trash
get-
trucks come. Sometimes they come.
Trash trucks. Okay.
Sometimes.
All right. And when you see the trash truck come and you see a mail truck in the neighborhood, what's the difference in the size between them that you recognize? Do you recognize the trash truck?
Oh, the
Perhaps
trash truck
twice
is
the size
much bigger. In
Yeah,
fact,
okay.
the mail
That's
truck's
good.
gotten smaller.
That's all. Yeah. Okay. Well, that was one of mine questions for you. I have questions that are more legal, I guess. So I'll hold those for a moment. Anybody have questions for the witness? David. Okay.
You said your driveway is blocked on several occasions.
Mhm.
It looks like you've got a metal fence across there, so they're not going up into your driveway, right?
Well, not the metal fence is there.
Okay.
we have a dog, so we keep.
You also
the-
mentioned in some of the publications that your property value has been diminished. How did you figure that? Was there appraisal done prior and appraisal done after?
We have not had two different appraisals. I'm certainly willing to do that. I think that obviously the diminished access, there's been times when I have come to the property, the road has been blocked. I haven't been notified. I'm unable to access. I've had deliveries of wood that couldn't be delivered because the road was blocked for, I don't know, resurfacing or something. But, there's multiple times where I can't get things done.
In the pictures that I'm looking at on those particular occasions, it's usually heavy traffic all over the island anyway. Those parking spots are filled, but yet there looks like there's parallel to those parking spots, there's people parked there, or at least
They're not
stopped.
supposed to, but they do.
Yeah.
Right.
Have you contacted the town police to make sure that those guys are gone,
Yes.
towed? Okay.
I was going to say that's exactly when I look at these pictures, it's just people parked all over the place down there. Like,
Yeah.
They just
I'm not sure that no matter what parking was striped would make any difference, apparently, because everybody's parking anywhere they want anyway.
Well, the biggest issue, obviously, is the cars backing up into the right of way.
Yeah.
The same time as the cars are going down the road. It still is a road. There are still 3 addresses on there.
So the other question, from the end of the parking spot is 18 feet deep, 18 feet from there to the her property was 29 point something feet. What's the normal width of a road?
I believe in the ordinance, it's required to be 24 feet. The interesting distinction, though, is if this is in fact a parking lot, then I don't know if that's actually right of way. For example, because a normal parking lot, obviously, folks, to get in and out of a perpendicular space,
Right.
you have to be able to back up. Correct.
Right.
So if you think of it in those terms, if it's a parking lot, then you're backing in and out of the space just as you would any other off-street parking lot. But 24 feet is the standard.
One, before you say that, the 29 feet, though, was measured to a point that's not in front of their property. It's a property somewhere else. And looking at the plan, it looks as if their property would be greater than that.
I believe so.
Okay. All right. You had an objection you wanted to raise or
I was
something?
just going to say he can make his argument, his side of the case.
Okay.
If he needs.
Well,
Can I just say one, you referred to this piece of property as a parking lot.
I did not.
Oh, okay.
That's one of the questions I have.
Oh, okay, because I do want to point out that it's on the POW bill map. So the
What?
POW bill map, that is how the state distributes funds for state maintained roads.
Objection. Move to strike.
Yeah.
This isn't about a POW bill map. It's not about the law governing POW bill maps, which I have litigated my share of. This is about whether or not the zoning determination that this is not a development and therefore does not come under the UDO was appropriate or not.
I sustain that one. So, okay.
I'm just commenting on whether it's a
Okay.
road or.
Do we have any
a
other
parking lot,
questions,
that's all.
Bruce, or for the witness on her testimony?
No.
Okay, Karen?
No.
Okay.
Okay.
All right. Well, if you're finished with your testimony, then,
I'm going to formally move to admit exhibits 1 through 10.
okay. Yeah.
No objection.
I don't have an objection to that either. I agree
You
that
wanna-
would be good.
For purposes of the record, Jeff, do you want to, Mr. Rother, do you want to identify that notebook 1 through 10 as Exhibit 3 as a collective?
How procedurally, however, folks want to do it. Just for the record, to be clear, the exhibits that Ms. McFarland referenced were provided to the board members and to the clerk in a notebook that's labeled Fairland Investors Appeal, the Town of Sunset Beach Board of Adjustment, August 13, 2025. There are 11 tabs, and the documents that we moved to admit, which I understand have been accepted, are behind tabs 1 through 10.
Right, and
Yeah, and if you want to mark the binder as 3, that's fine.
Yeah, exhibit number 3.
Yeah.
Exhibit 1 is the staff report. Exhibit 2 is his entire copy of the UDO.
Yeah,
Exhibit
exhibit
3 is
three
the
is-
entire notebook, tabs 1 through 11, including
The UDO accepted.
A through E.
That's fine with me.
And
I actually have questions of Ms. McFarland, and what I'd like to ask is, may I please roll this lectern over to the side where I'm able to see the entire board and also be able to address Ms. McFarland?
Thanks.
Ms. McFarland, do you have the notebook in front of you?
Uh,
Okay. If you'll go to tab 2, which appears to be a tax GIS map that's part of your notebook, do you see that?
yes,
Okay. As you're looking at this tax map, where is your home located?
the bottom right corner with the number 1405 on it.
Okay.
Thanks.
In advance of today, have you ever undertaken to review whether or not the town's parcel shown there as 263HA001 is under any zoning classification in the UDO?
We have tried to determine the ownership of that parcel.
That wasn't my question. Have you tried to ascertain whether or not there's a zoning classification for that area of land?
Zoning classification for a road.
No, for the town's property shown there, that's the
We
subject
have
of
been
this.
unable to determine a zoning classification because we have been unable to determine ownership of that parcel.
How does that?
Mhm.
it's owned by the township, is it not? By the town?
They can't, there's no record of the transfer.
Well, we would object to that. No, I asked the question about the zoning determination. No, Mr. Rother. Let's not kid ourselves. My question was just about whether or not she had made any efforts to ascertain the zoning designation for this strip of land. It had nothing to do with ownership.
Okay, all right. Is it, okay, good. All right,
I'm asking the question.
I got you.
I'm
All
not
right,
giving
please proceed.
testimony. Have you ascertained under the UDO what zoning district this piece of land that's the parking lot, what zoning designation it has?
I have not been able to find a zoning designation for this road.
Interesting.
Now, with respect to the picture shown behind tab 5, there's two pictures actually behind tab 5.
Mm-hmm.
Did you take those pictures?
No.
You know who did?
It's a Galaxy. Was it Ron? Was it you or Chris? It was either Ron or our neighbor.
All right, well, she answered the question. She did not take the pictures.
Ms. McFarland, with respect to tab 4, the survey, the area that's depicted on that survey, is that the area that is also shown on behind tab 2 with the tax parcel GIS aerial image of 263HA001?
Yes.
And in the picture that's shown on the tax GIS map of 263HA001, is that area shown as being paved?
Yes.
And with respect to the pictures behind tab 5 that show new pavement, do you see those?
Yes.
That new pavement was laid over the areas where the old pavement was?
Yes.
I have no further questions at this time.
Jerry, do you have any questions for us, the witness? You don't have to ask. Okay. If that's all you have to
I
say,
just
then.
have one final statement, and that is just that through this appeal, we are merely asking the board to require the town to follow the correct process. It needs to hire the appropriate professionals and review whether the parking plan meets its own land development ordinances. Thank you for your time.
Can I just ask one
Yeah,
redirect
sure.
question to make sure that it's clear for the record? Mr. Richardson asked you about certain pictures and whether you took them or not.
Right.
You were familiar with what the area looked like at the time the work was
Yes,
being done,
it,
correct?
the same. Now, I did not take this particular picture. However, I did go down to try to access my property, and this was the condition at the time. I could not access my property because the road was closed.
Okay. So that the photographs in Exhibit 5,
Exhibit 5.
accurately reflect what the area
Yeah.
looked like at that time.
Yes.
In Exhibit 3, tab 5.
Yes.
Thank you.
Okay. All right, well, that was for a period of days, and it's no longer in this condition?
Correct.
All right. Okay. Any other witnesses?
No other witnesses. As long as exhibits 1 through 10 in the staff report, or sorry, if exhibit 3 is in evidence, which I understand it to be.
It is now.
Thank you. And with the staff report and the UDO being taken of notice, we don't have any other further evidence at this
Okay.
time. I understand Mr. Richardson may have some evidence to put in.
That's correct.
I'm ready.
At this time, I'd like to call Wes McLeod to the stand. Mr. McLeod, will you state your name and what your role is for the town of Sunset Beach?
My name is Wes McLeod, principal with Anchor Point Planning, and we provide planning consulting services to the town, have been for some time.
And Mr. McLeod, in advance of today's hearing, had you reviewed the contents and the entire contents of Exhibit 1, which is the staff report before the board today?
I have.
And do you agree with the contents of the staff report in terms of its accuracy?
Yes.
Do you agree with the zoning determination that was made by Lisa Anglin that, from which the appeal was taken by Fairlane?
I do. Yes.
Mr. McLeod, do you have the appellant's notebook in front of you?
I do not.
Yeah, pass one.
Do we have an extra one?
Thank you.
So, Mr. McLeod, if you'll go to tab 2 of the appellant's notebook,
Share, okay.
do you see the aerial tax map view?
I do. Yes, sir.
Okay, we're good.
We'll wait for.
Thank you.
Okay, so the parcel in question that has the town's parking lot, is that properly labeled 263HA001?
It is.
Are you familiar with the town's UDO?
I am. Yes, sir.
Does the town's UDO have zoning designations and classifications?
To my knowledge, there is no zoning designation for that particular parcel.
So there's nothing like rural agricultural, multifamily business, commercial, any sort of zoning designation for this parcel of property?
Not to my knowledge.
One minute. Do you have, I'm sure you don't, I'm gonna hand up. I'll approach with the staff report. Actually, I think I've got an extra copy. Just give me a second. If you'll go to the second page of Exhibit 1, under the UDO information, do you see that? Should be the second page.
Yes, sir.
Okay.
Yes.
And under, you see at the bottom, section 2.14A, minor site plans.
Yes.
Does the town's improvements to the area in question, in your opinion, constitute the need for a minor site plan?
Seems to be testifying, asking him to testify as to the ultimate conclusion in this case. His ultimate conclusion is not relevant. It's Miss England's.
Well, he's also our hired consultant that applies and interprets.
I'm reading him as an expert witness.
The interpretation's been made. We know that it's been made.
Okay.
So if he's be asked to testify as an expert of the law, that doesn't seem proper.
I'll withdraw my question.
Okay, fine.
At this time, I have no further questions of Mr. McLeod.
Okay.
So I have a few
Go ahead. You
cross-examination
can ask
questions,
questions.
if you don't
Go ahead.
mind. Thanks for your time today. The parcel of land that you identified that was on tab 2 of that binder, the town's property that we're here for today, that's within the planning jurisdiction of town of Sunset Beach, right?
Yes, it is within the planning jurisdiction. Yes.
Okay. And you mentioned that you're not aware of there being any zoning district classification for that property.
Correct.
Right. Okay. Zoning districts govern the scope of permissible uses on proper. Is that right?
Yes.
I have questions, but I think they're more legal oriented than having his interpretation. Unless you guys want me to, we'll start anyway. Okay. Anybody have a question for Wes McLeod? Thank you. Karen, Bruce? Do you have any questions for Wes?
Well, my question pertains to the definition of development.
Yeah.
And as I read this word for word, it says any land disturbing activity which adds or changes the amount of impervious or partially impervious land. This does not do that. Because the parking lot was there before, it was simply recoded. So we haven't changed its pervious or impervious nature, correct?
Correct.
Okay, or otherwise decreases infiltration of precipitation into the soil. We haven't done that because it's been previously paved. It also involves any man-made change to improved or unimproved real estate, including but not limited buildings or other structures, mining, dredging, filling, paving, and drilling operations, storage of equipment or materials. None of those are involved, correct?
Correct.
So I fail to see how this meets the definition of development in the ordinance.
Can I ask one follow-up question? So
Mhm.
there were parking blocks installed as part of this plan, right?
I believe that's the case, and you know, in reading the definition, the as part of the UDO administrator's interpretation was inferring to the references to improved and unimproved real estate, building, structures, mining, dredging, etc.
Okay. So there were parking blocks installed as part of the parking reconfiguration.
I believe so. That was on the plan.
The striping was changed.
Yes, sir.
Okay, and that was a man-made change to the land.
Yes, sir. Again, it was referencing the determination was made based on referencing that particular clause, including but not limited to buildings, structures, mining, dredging, filling, grading, paving, excavation, or drilling operations.
I just want to make sure that my question got on the record. I don't mean
Yeah,
to
sure.
be argumentative. I'm told that the microphone wasn't working.
Yep.
So the parking blocks and the striping that was done by the town, those were man-made changes to the land.
Yes.
Okay.
I have a question follow up since he's opened the door to it. For development under the UDO, Mr. McLeod, are you aware of this parking facility having any land disturbing activity that added to the amount of impervious or partially impervious cover that otherwise existed before the improvements were made?
Not to my knowledge.
To your knowledge, has any land disturbing activity changed the amount of impervious or partially impervious cover on the land in question?
No.
To your knowledge, have the improvements by the town decreased the infiltration of precipitation into the soil as part of the improvements?
No.
No further questions.
Well, good. Any questions? Yeah. Okay. All right. Go ahead. You have something to say, Richardson?
Well, I was thinking about calling Ms. Anglin. However, with the questions that Mr. McLeod just answered, let me just make sure I'm covered here. I guess to be sure, I'm gonna have Ms. Anglin go up and take the staff report with you, Ms. Anglin. Ms. Anglin, will you state your name for the record and your role with the town?
Lisa Anglin, and I'm the town administrator.
Ms. Anglin, are you the one who reviewed the zoning determination request made by Fairlane Investors LLC?
Yes, sir.
Okay. And are you the one who made the zoning determination that's set forth in the staff report, Exhibit 1?
Yes, sir.
Ms. England, how long have you been employed by the town of Sunset Beach?
Since May of 2010.
How long have you been the town administrator?
4 years.
How long have you lived in the town of Sunset Beach greater area?
I live in the county. I don't live in Sunset Beach.
How long have you, well, have you visited the town of Sunset Beach through all the years?
Yes, sir.
How long have you lived in Brunswick County?
My entire life.
Okay. And how long is that? Sorry.
60 years.
Okay. So, have you ever, before your role in 2010 with the town, had you ever gone to the West End and seen this area that's in question today?
Yes, sir.
And was it used as a parking lot then?
Yes, sir.
How long, to your personal knowledge, has the area been used as a parking lot?
All my life that I can remember, that area was a parking lot.
And has it, to your knowledge, always been paved?
No.
How long would you estimate it's been paved?
Probably 30, 40 years.
Now, with respect to the improvements that were made to the parking lot that's in question today, did you oversee those improvements as the town administrator?
Yes.
And based upon your own personal knowledge and your role as town administrator for the town of Sunset Beach, was any land disturbing activity conducted on the parking lot that added to the amount of impervious or partially impervious cover?
No, sir.
Same question. Was any land disturbing activity, did any land disturbing activity change the amount of impervious or partially impervious cover?
No, sir.
To your knowledge, and the same question based upon your experience and oversight of this project, did any of the improvements decrease the infiltration of precipitation into the soil?
No, sir.
I have no further questions at this time.
Okay. Do we have any questions up here for Ms. England? David, any questions?
No, sir.
Okay. All right.
I have some questions if I
Well,
could cross-examine, sir.
Please.
Thank you very much. Ms. England, do you have the notebook in front of you?
I do not.
Yeah. If may I approach,
Well,
or if there's another copy we can give.
yeah, pass it over.
And for reference to the binder that was entered as Exhibit 3, can you take a look at the document behind tab 6? That's your signature on the document at tab 6. Am I correct about that?
Yes.
And that document reflects the work that was performed in connection with the parking reconfiguration.
Yes, sir.
And you testified that you've been familiar with the area to the west of 40th and Main Street for quite some time, right?
Yes, sir.
All right. Prior to this spring, there was parking allowed in a parallel parking orientation. Is that right?
Yes, sir.
Okay. And the parallel parking was on the shoulder of the road, right?
Mm-hmm.
Okay. With all your familiarity with that area to the west of 40th and West Main Street, it was open to through traffic that before the spring. Is that correct?
Not through traffic.
Well, there was a dead end,
Mm-hmm.
right? And there were driveways that served as ingress and egress for 3 properties.
Correct.
Okay, and those 3 properties still rely on that area for ingress and egress. Is that right?
Mm-hmm.
Okay, so that area it was served by parking, but is also there's the right of way there for those properties. Is that correct?
Yes.
Nothing further.
Okay. If there's no other questions from up here, then I have some questions about, I think this applies. First off, a lot of people have been calling this a parking lot. And I was wondering, Jerry, or Brady, which one do I address? But this parking is in the right of way of the road, is it not? Wouldn't that be called it's on-street parking versus off-street parking?
So To make sure I follow your question, I think it serves both. I was using the parking lot moniker for convenience sake.
Yeah.
Clearly, it's used as a road to get to and from the parking spaces.
Yeah.
It's not entirely a parking lot, obviously, because the appellants use that area to access their home. There's other homes along that area as well.
Okay.
Mr. Chairman, I'm happy to address that.
Please.
With the short answer and the long answer, okay? The short answer is that parking lot is defined in the UDO.
I've read
And,
that.
and parking lot is defined as an area or plot of land used for temporary parking of vehicles. And so they're certainly using that area in the right of way as a parking.
It's where is that pad? Just my
So
clip just bounced off.
In the staff report,
It's in.
page 3, they excerpted the
Yeah, but there's a little bit more than just what you suggested.
correct. So page 3 of the staff report definition section 7.3 states parking lot, an area or plot of land used for temporary parking of vehicles. Parking lots used as a principal use shall be subject to the use standards provided in section.
That's in 7.3, you said?
Yes, sir.
Right. It's in the descriptions down there. There it is. I got it. Okay. Okay. Well, if you go over to sections in 3.8 and 3.32, in the UDO, those sections, there's a lot of discussion about off-street parking and how how many parking spaces are required for the facility that parking supports, etc. And I was looking for some interpretation from our attorneys here that this is or isn't a parking lot because it's street parking.
So, Chairman, I'm happy to answer your question. I'm going to have a presentation of the UDO provisions. I'm not deflecting your question. I'm happy to go through it. I'm happy to address it now. I'm just trying to make sure that we address it at the appropriate time in the hearing. To address your question now, as I understand you'd like us to do, I'll walk through it. So, section 7.3 of the UDO has a definition of parking lot, which we referenced.
Yeah.
It says that an area or plot of land used for temporary parking of vehicles. That's certainly what's going on right here. The next sentence says parking lots used as a principal use shall be subject to the use standards provided in section 3.8.
Yes.
So if you go to
Correct.
section 3.8,
Yes.
3.8R, 3.8R says where permitted, right, the following shall apply. Landscaping, buffering, and parking lot design shall adhere to the standards of this ordinance. Right. So section 3.8R provides cross-reference to other applicable provisions of the ordinance. What you need to go to there is section 3.32.
Yeah, I didn't reach the 3.8R yet.
3.32 has requirements on parking.
Correct, which is
And these are the matters for which we believe UDO and site plan review is required to confirm that the parking, what they've created as a parking lot is UDO compliant. There's a separate issue. There's two different issues going on, right? What's
Right.
before the board is compliance with local code. There's this entirely separate issue, which hopefully will never have to be litigated, but we can figure that out later, as to whether what the town has done here, whether they've effectively closed the right of way in violation of 168-299. Because the town hasn't gone through the process for closing a road.
Objection.
There's a way to do that.
Objection. That is not before this board.
That's what I just said. It's not.
Then
before
why are
the
you
board.
arguing it?
Because he's
You're
asking
wasting
me.
time.
He's asking me the context of
You're
whether this is a
trying
parking lot or
to, no,
not.
you're trying to put in inappropriate material before this board to confuse the deliberations that this board needs to make.
It was not part of my evidence. The chair asked a question, so I gave him the most complete answer that I could give. Is that there's the issues that are
Objection.
before this board today,
Okay,
and there
all
are
right,
other
all right.
issues involved with this question that aren't before this board.
Got it. Good. I understand. Okay. Well, typically in a variance or it, when we talk about variances here before the board, there's 4 criterion that have to be met, and this is not in that.
This is not that category.
Some are down.
No, and this is, also, would you agree that something like this, being an interpretation of an appeal to a determination by staff, that it would be a simple majority as opposed to the 4/5?
It is a simple majority.
Okay.
And you can think of this, you may get an objection from the crowd, but you are pretty much standing in the shoes of the UDO administrator.
Okay.
And it's, it's competent material and substantial evidence in the record
Right.
that you're basing your
Right.
decision on, and as part of that is also
Okay.
relevance to the issues.
Yeah, and
Okay, I'm about to close the meeting for public comment.
so, Mr. Chairman, I just wanted to make sure. Did Mr. Richardson? Do you have any further evidence? I'm sorry, I didn't hear if you closed or not.
No.
Okay. I'd like to give legal argument before you deliberate.
That's what
I do think the evidentiary portion of the hearing can certainly be closed.
And I too wish to be heard on a closing summation after the applicant.
Okay, well, we've heard all the evidence we're going to hear then, so we're closing the meeting for that perspective. I was going to ask for deliberation, but I guess I should wait until I hear you folks, both attorneys, speak before deliberation of the board.
Thank you, and
So
we'll certainly try to be very brief.
Yes.
Would you like us to use the podium again? I don't. It's to the side now. I'm happy to address the issues here.
You've got a microphone that works.
All right. Thank you very much. Mr. Chairman, I appreciate your time and attention. Again, Jeff Rother for Fairland Investors, LLC. The central question today is the town subject to its own rules with regard to this parking work. And as Mr. Manning just stated, you're standing in the shoes of the zoning administrator that was in the same spot as when we made the original request or determinations. So that central question, is the town subject to its own rules? The answer is yes, and it's clearly set forth in the town's regulations and the town's UDO. What I like to do is to walk through the important provisions that govern this issue that lead to that conclusion that the town needs to go through the normal process that every other landowner must follow. If I may approach, I just have a handout with some of these excerpted.
Wouldn't that be more?
It's not evidence. It's excerpts of the UDO put in an order of evidence that's already in. It's a
Summary of
demonstrative PowerPoint. So the town put some of the UDO sections into the to the staff report, but there are others that I believe are pertinent here. And then the first page, we'll start with section 1.4A, which is the town's UDO states that the regulations in that ordinance shall apply to all property within the town of Sunset Beach, within the town of Sunset Beach planning jurisdiction. And you heard in the evidence that this property certainly is within the planning jurisdiction of the town of Sunset Beach. So the ordinance applies to this property. The next section, 3.1D, which is no land within the town's planning jurisdiction shall be developed except in accordance with the zoning district use and development standards and requirements of this article and all of the regulations of this ordinance as applicable. So there are no carve-outs there for the town. The UDO applies to all land within the planning jurisdiction of the town of Sunset Beach and clearly provides that no land within the town's planning jurisdiction shall be developed except in accordance with the UDO standards. And we'll get into the topic of development in just a bit. But before we get there, I do want to address one issue that the parties haven't addressed yet, is that Ms. England's determination included a determination that the town is not subject to its own development ordinance under 160D-913. And as I understand her position, that it applies in this situation such that the town's only subject to its own ordinances with regard to buildings, but not other improvements of land. And that's not right. 160D-913 applies to local governments attempting to regulate other government entities. So if Brunswick County owned land in Sunset Beach, that would determine the applicability of Sunset Beach's ordinances as to the county. Or if there was another state agency that owned property here looking to develop, that's when that ordinance comes into play. As we laid out in our appeal, the applicable standard here is whether the government is acting as a proprietary versus governmental function. And briefly, this is certainly a proprietary act because it's the same act that any other landowner can do using property for parking in exchange for a fee. That's a proprietary act. But the good news for this board is that topic, I don't think the board has to decide that today. Because two reasons. That's an issue of state law. If the town believed that it was exempting itself from its UDO, from its zoning regulations, it should have put that into the UDO, right? It clearly section 1.4 and section 3.1, that ordinance applies to all land within the jurisdiction and without regard to the ownership by the town. And it prohibits all development except in conformance with town standards. So what this board's job is to apply local ordinance. It's not to take on issues of state law or what the town could have done if it decided to write its UDO differently. It's this ordinance that's before this board today, and apply this ordinance to the facts at hand. So I think the first conclusion that's very clear is that the UDO applies to all land, including the land owned by the town, since it's in the planning jurisdiction. So the next issue that we get to is development, right? Is what the town's doing here considered development? So the next paragraph that we put in the slides is the definition from section 7.3. And what the town is doing is respectfully focusing on the first sentence. If the definition of development ended with the first sentence, then this issue would be entirely different than what I'm advancing, is that you got to read the whole thing together. And that's one of the central canons of ordinance construction under North Carolina law, is that all ordinance provisions must be read together and construed in harmony and given full effect to make any such section, make no sections meaningless. So it's not just a matter of whether the area of the right-of-way had more or less impervious surface than it did before when there was parallel parking. It's not whether there was any additional infiltration of soil. The definition clearly states that this also involves any man-made change to improved or unimproved real estate. So this was land improved with pavement, and there was a change made to it. As you heard the testimony, parking blocks were installed, signs were put in, the striping configuration, which is not just someone going out there with chalk, that's a permanent change to the land. That work was done and the land was changed. The implications of just focusing on that first sentence and not on the second are staggering. And I'm frankly surprised that the town is taking that position, because things like that, there are plenty of development activities that don't change the amount of pervious surface that would no longer be development and no longer be subject to the town's regulation if that interpretation takes effect. Mining, grading, right? It's this second sentence uses the term including but not limited to capture those types of things. Grading is moving dirt around. It doesn't add any impervious surface to the situation at all. but it's certainly development. I don't think anyone would ever question that. Mining, right? Taking earth out, right? It doesn't add any more pervious surface, but it's certainly development. And what the town is suggesting here is that all you have to do when you're changing land, when you're changing real estate, that you could do whatever you want as long as you're not changing the amount of impervious surface. What the town is saying is that changing this parking configuration is, they can do whatever they want as long as they don't add more pavement. And that's not right. And I respectfully suggest that the situation would be a lot different if this was a private developer trying to open their own parking lot here in town for paid parking, as opposed to the town. Under the town's interpretation, any private parking lot owner could come in, change the configuration, do whatever they want, let people back into the right of way, and have whatever wild and crazy configuration with not even worrying about how big the spaces are. You're asking those questions about how wide these spaces are. You can do whatever they want, because as long as they didn't change the amount of impervious surface, that's not development, so it's not subject to plan review, and it's not subject to the UDO. That, to me, is absolutely crazy. That the town can take that position when it's its own development activity, because they would take the absolutely opposite conclusion if it was a private property owner wanting to operate their own paid park. So respectfully, development is not just implicated by whether there's a change of impervious surface. Development includes activity that adds or changes the amount of impervious surface. It also includes man-made changes, improved or unimproved real estate, including the things we're talking about: changing striping, adding blocks, moving signs. That is development activity. And therefore, the activity that the town undertook is subject to UDO review, including site plan review. The next sections, I think this may be a little bit nuanced, because Ms. England's interpretation said that the town is not subject to UDO review, including site plan review. But I added the sections of section 2.14A and 214B on the next 2 pages, because seeing these 2 sections together, I believe is helpful, because what 2.14A provides is that certain types of development require minor site plan review. And 2.14B provides that other development not subject to minor site plan or special use permit approval requires major site plan approval. Ironically, 2.14AC, right, talks about development including signs, right? So, I mean, there were signs installed here, but I think that's moot, since development certainly includes the activity that was occurring here. Moving on, the next question, and I want to make sure it's clear, is that what we're talking about is not use, right? So there are 2 different things in a zoning ordinance. There are use standards, right? You're in a residential district, you're in a commercial district, and the use table determines what kind of uses can you undertake on your land depending on what district you're in. We're not challenging whether there can be parking here. That's an issue of use. And so the point that people have been parking on the side of the road for 25 years doesn't matter. We're certainly not challenging the ability to use property for parking in that way. What we're talking about are development standards. And once you undertake a use, how can you go about doing it? What are the standards that apply? And it's not just in parking. You're talking about configurations. It happens with, buildings with setbacks and parking requirements. If it's an accessory, parking's accessory to buildings. These are the standards that are complementary to use standards. Once you have a use established, how can you go about using it? So that's exactly what we're talking about now with return in terms of this parking configuration. Now that this area is certainly a plot of land used for temporary parking of vehicles. I think it's certainly under UDO definition being used as a parking lot as defined in section 7.3. And in fact, Ms. England's determination said that it is a parking lot. So I don't think there's any dispute that as of now that they have been using the property as a parking lot on area that is a right of way. And then as I went through with the chairman before, the parking lot definition cross-references to section 3.8R, which then cross-references to 3.32. So 3.32 certainly has a lot of the criteria, and this is exactly what we are asking the town to review. I put in our original request for an interpretation that Ms. England determined that the plan does not meet UDO standards, because it seems pretty clear that it doesn't. I haven't tried to undertake a review of every single technical requirement like lighting and landscaping and all the other things that apply to parking lots. But what seemed clear as day is that the town's UDO provides that parking shall be designed to avoid undue interference with the use of public streets and alleys, and the vehicle shall not be permitted to back into any right of way. And that's exactly what this parking configuration provides for, and actually promotes it. It's not just a matter of permitting it, that's how it was designed. So what I would respectfully request is that the town, well, I'll step back for a second. As Mr. Mann had said, this board stands in the same shoes as Ms. England did when she received our original request for interpretation. The board's job is to take the evidence that it heard and apply it to these UDO standards. Clearly, under the UDO standards, that this is development. Clearly, under UDO standards, the town's development regulations apply to this property, whether it has restrictions as to uses through a zoning district or otherwise. And clearly, that this parking configuration has established a parking lot that interferes with access to and from the 3 driveways there to the west of 40th and Main Street, including the property owned by Fairlane Investors, and provides for vehicles to back into that right of way. Now, the last slide is exactly why that type of review is required. That's one of the pictures that was introduced into evidence. That's the area to the west of 40th and Main Street. And the reason we have rules is to protect the public. We can argue about whether Fairlane Investors should have to be dealing with this amount of activity outside of its property. That's not why I'm providing this picture. This picture is showing exactly why we need review standards, because the public is coming in and out. It's not just the vehicles that are entering the area and exiting and not having a place to safely move. People are going to and from that area on foot, and without the proper checks and balances in place is where. So I put that picture in that slide to remember, is like, that is why we have these standards. To make sure that the town has reviewed that what they're doing on land is protecting the health and safety of the public, just like it would undertake that review for any other private property. So I'm happy to answer any questions about the UDO standards or North Carolina law. I know that Mr. Richardson is going to want to provide his own legal argument. I'd like to reserve at least a quick opportunity to address anything that he may bring up. But I do respectfully ask this board to reverse Ms. England's determination, find that this activity is subject to UDO compliance, and further find that the parking configuration is in violation, given that it provides for drivers to back up into right of way. Thank you.
Okay, thanks. thinking about what you said, reserving the right to counter what Richardson's going to say. It's
You don't have to give it to me,
could
but
we could go countering and countering
Yeah,
all
I
day long.
understand.
So I'd rather
I'm
not.
not suggesting that we.
All right. Let me talk to hear what
That's
Mr. Richardson has to say, though.
Thank you, Mr. Chairman, members of the board, for being here today. Appreciate you listening to us. Your scope of your determination today is governed by what their appeal said. Nothing else. So when you look at Exhibit 1, which is in the record, you go to Mr. Rother's appeal. It's attachment 1. It's about 5 pages in. May 20th of 2025. Okay. So after the prefatory first page where he's given notice of appeal and he's summarizing what got us here, he then goes into, on the second page of the appeal, the notification of what he's appealing. He leads off by saying Fairlane disagrees with the decision and it should be reversed for the reasons stated herein. First, the UDO's definition of development. Okay, we'll get to that in a second. Number 2, the town is subject to its own development ordinances with respect to its parking lot on the site because the development and operation of this paid parking lot by the town is a proprietary act. He then cites to the McKinney case from 1953. We'll talk about that. After that, he doesn't identify anything else. He doesn't talk about Section 3.32, parking standards. He doesn't ask for you to find that the town is in violation of the town's UDO. You don't have jurisdiction to make that determination that the town's in violation of its UDO either. It's just about the interpretation that he requested, his disagreement with that interpretation, and the 2 grounds for his appeal. Now, he says, as well as other matters that will be explained and proven at the hearing on this matter, he doesn't identify what those are. The first I've heard of him claiming that there's any violation of the parking standards was today. Okay? He doesn't say, you would think if it's that important for him to spend almost half of his summation on it, he would have put it out in his notice of appeal letter. He did not. Now, let's look at, so with all due respect, any argument he's making about Section 3.2 and parking standards should not even be considered by this board because it's not part of his appeal. I don't believe it applies either, so I can touch upon the reasons for that as we go through this hearing. Let's also start with his last page of his summation showing the traffic jam at the end of the street and parking lot area. We all know that his clients could call the police. His clients could call a tow truck company. There's nothing on this side of the street that's in that picture that's part of the parking lot facility on the other side of the north of this area. Cars are parked there. People are gathering in the middle of the street or this area, but the cars parked on the southern side shouldn't be there. That's an enforcement measure. That's not something that this Board of Adjustment should weigh into consideration of this appeal, because whether or not we had 5 parallel parking spaces there or 14 perpendicular spaces, those cars that are shown on their side of the road shouldn't be there. And there's nothing that can prevent that, even if we only put 5 parallel parking spaces back. It's an enforcement measure that his clients, can also partake in by calling the police and having those cars ticketed or towed. Now, he spends a great deal of time going back through his summation about how the town is just focusing on the first sentence of development. Well, the first sentence governs the scope of the second sentence. So when you're reading the 2 sentences as he wants you to do in conjunction with one another and in harmony with one another, that necessarily means you're reading the second sentence within the scope of the first sentence, setting the boundaries of this provision. That says any land disturbing activity. So the whole point of this provision is about land disturbing activity. But then it says further, which adds to or changes the amount of impervious or partially impervious cover on a land area, or which otherwise decreases the infiltration of precipitation into the soil. So it's setting the boundaries there that we're talking about a land disturbing activity that adds to or changes the impervious or partially impervious cover or decreases the infiltration of precipitation. That's it. So the second sentence, when it says this involves, necessarily means this is referring to land disturbing activity that changes the impervious or partially impervious coverage. It's not about all land disturbing activity that could include man-made changes to real estate, buildings or other structures, mining, dredging, filling, grading, paving. Mr. Rother also wants you to conflate a couple of things here. We're not talking about a private party seeking to build a parking lot. We're not talking about a private entity or a land developer. There are different rules that govern a municipality. This municipality is not governed by the same rules that a private land developer is. They're just not. And I'm going to talk to you about the law in a second. So that's borne out by the law in North Carolina. In fact, in his appeal, Mr. Rother went through a great deal of case law he wanted to cite in here, which I've read. But he doesn't mention a case that's directly on point, that's been decided much earlier and much more recently than a 1953 case that he relies upon of McKinney. Mr. Manning, may I approach with some case law?
Get one? Hey, can I get one?
Everybody have a copy?
Except me.
Might want to have you.
Thank you.
The other thing I want to hand out is we've all heard of the School of Government, and David Owens is the leading School of Government guru, and I'm going to hand that out as well. So what you're looking at, the first thing, the Government Buildings and Land Uses by David Owens, that's done for May of 2023. In the first paragraph, he's talking about the history that came in to legislation of the 160D-913. Mr. Rother says that doesn't apply to the municipality because it only applies to other political subdivisions. But the legislation says that the statute makes city and county zoning regulations applicable to, quote, the erection, construction, and use of buildings by the state of North Carolina and its political subdivisions. Thus, if a building is involved, zoning restrictions apply to land uses owned or operated by cities, counties, and the state. Going down further, the statute does provide, however, that land owned by the state agency may not be placed in an overlay or conditional zoning district without approval of the council of state. Most importantly, since a building is required, let me repeat that, since a building is required to trigger application of zoning, and given that land uses per se are not covered, quote, this is from Mr. Owens, an open air use of land without a building is not subject to local zoning. The Court of Appeals held in Nash Rocky Mount Board of Education versus Rocky Mount Board of Adjustment that construction of a new bus parking lot at an existing high school was not subject to city zoning jurisdiction. I've got the Nash case for you that I've handed up, and that's good law. That's from 2005 that holds for that proposition that if it's not a building, it's not subject to land use and zoning, which was the second prong of Miss England's determination. The first prong was this isn't a development under the UDO, but alternatively, it's not subject to zoning regulations based upon the law I just handed up to you. And for those reasons, the appeal should be denied. The appeal should also be denied because this is not a development under the under the UDO based upon a careful reading of those two sentences of land disturbing activity. Even if it were, assuming arguendo, it's not something that falls under the zoning regulations because of the ruling in Nash versus Nash Board of Adjustment. The third thing is his additional appellate argument about parking standards is not properly before this board and should not be considered. I could go on, but in the interest of time, it's our position on behalf of the town staff that the town staff got it right and that this board should affirm Ms. England's determination. And we appreciate your time today.
All right.
I have 90 seconds.
Okay.
Okay. The first contention that we didn't properly preserve this, the appeal states that it should be reversed for the reasons stated herein and the request for interpretation, which details section 3.32. The idea that Mr. Richardson didn't know I'd be relying on that is just wrong. I mean, it was in our original letter. Section 7.3, it was noteworthy when he says this involves any man-made change. He forgot to say word also, which is the critical word. It also means in addition to. Third, I did not omit the Nash County case that he handed you. I cited it in my appeal. I was the one that brought it up. It states that in North Carolina, the General Assembly has determined that a city or town may exercise its zoning power as to other governmental entities in the limited circumstances set forth in 68-392. This case that he handed you, it stands for the exact proposition that I am stating. I'm handing you, I provided cases from the Court of Appeals and the Supreme Court. I respect Mr. Owens, but he's a guy. He works for the School of Government. This is the Court of Appeals. That's what matters. And as Mr. Mannon nodded in agreement, I'm sure he'll confirm for the board, that's not an issue for this board to determine. What's the issue for this board to determine is what rules did the town make to all land within this jurisdiction, and it's the rules that are in the UDO. Thank you.
I'd like to close discussion in the public and or the attorneys. I would ask that you, if you would, we're going to go into deliberation and then vote on what we want to do. And I'm going to want to ask if there's any direction from you before we do that. Anything special you want to tell us or anything?
Nothing special. You can affirm the decision of the UDO administrator. You can reverse the decision. You can modify the decision.
Okay.
You can kind of do what you want.
Okay, good.
And it's
All
it's a 4/5.
Uh,
No, I mean simple majority. I'm
simple
sorry,
majority, right?
simple majority,
Okay.
and again the competent material,
Okay.
substantial evidence.
I'm going to ask Bruce over. Would you please go first? Deliberate about what you're thinking about this case and where you stand.
Is that a vote?
Well, you can vote at the end of it, but yeah. Tell us where you stand. That's called part of the deliberation, and then we'll take an official vote to either.
I don't see where zoning is required. I tend to follow the. All you've really done here is coat the parking lot and change the striping on it. No different than on-street parking. I don't see where putting a curb stop constitutes anything. So that's where I'm at.
Okay. And I was going to ask you next.
Yeah, I
Okay.
think it comes down to I don't see where We did change any footprint on that particular area. We did change the dynamics of how it's being used. That should have come into consideration on the overall design. But as far as the UDO administrator's definition, I think she's on point.
Karen, I have to ask the same question. Okay.
That last picture,
Yes.
when it was parallel parking,
Yes.
did they not park on that side also?
I'm sure they did.
Okay, so that, I don't see where that makes any difference.
Well, the picture doesn't.
Yeah.
I agree with that.
So I agree with,
Okay.
the same.
I
So David?
concur. I don't think we changed any, I don't think it meets the development criteria. You did.
Okay, good. Well, that was actually what I was going to point out as well. I don't think that this meets the terminology for development. To me, this is on-street parking. It's been reconfigured to be one way versus another way. Adding curb stops is something that could be done regardless of whether it's what shape the parking spaces are put in, as well as signs that say you can park here, you can't park here, or whatever. It's paid parking now, since the town has moved to paid parking. So I didn't see this as a development. I saw it as on-street parking, and because of that, I would confirm the same decision. So I confirmed the decision of the the town administrator. So for formal purposes, I think I need to take a motion from someone that we would confirm the, I guess the proper way to say this would be to deny the appeal of the applicant. And I'm looking for someone to make that motion. And
I move.
all right, we need a second.
I'll second.
And now we'll take a vote on aye if you agree.
Aye.
Aye, aye, aye. All right, that's 5 unanimous. We agree that the appeal has been denied.
Your time.
Yeah. Move on to the other. Okay. Yeah. Okay. I don't think we need to take a big break here. I think we can go right on.
I'm good.
Okay?
Yeah, I'm good.
Okay. Then let's move on to the next agenda item, which would be variance 2025-02. There's a staff report and summary background that we'll take in a moment. As soon as the meeting room is ready. Don't worry about the chairs. Okay. Now, we lost our attorney. Is he supposed to be here for this one? We'll wait. There are applicants that are going to testify today.
They need to be sworn in.
You need to be sworn in. Just yourself? Yeah, attorney isn't really giving testimony. But if you're going to testify, we need to swear you in.
Yes, Mr. Chair. Yeah, just wait a second. You'll need to make sure to formally close that other hearing.
Okay.
And then open this one as well. Just the procedure.
Okay. I thought our vote that said it was officially
I
been
will
denied.
just for the record, just
ends
make
it.
sure it's crystal clear.
I would rather push on. There's things to be done after.
Why was this one coming before us?
That's the first question.
Okay.
So if you're the applicant for the next case, sir, if you need to take a break, I think it seems like you have a minute to do so. And you too. I'm going to sit here though. I'm not gonna move.
Ouch. Was that me? Was it? Yeah. I think they're trying to work it out.
Get yourself set up nicely. Your client is taken out. Side for a moment.
Fine.
No, sit there. Be fine, please. Okay. Okay. Jerry, do you believe we have to formally close the first case? I thought it was once you take a vote and it's closed. Close the public. We close the. Okay, good. All right. So we're moving on to variance 2025-02, and the first thing on that here would be that you hear from our staff report summary. Yes, sir. Oh, you're right. We should probably hear from the attorney first. Do you have a mic? Seems to be on. Got it? Up on top there.
Mute button on top.
On the top, there should be a green. All right, now you're on.
Okay.
Please proceed.
Yes, it's a potential jurisdictional matter is whether or not that this is appropriate request for a variance. That, and I think some evidence needs to be taken, and that be a preliminary threshold decision that if the board decides that this is appropriate to be heard as a request for a variance, then we would take evidence and you would treat it as you normally would. But if you determine that this isn't a proper request for a variance, perhaps it could be another request for something else, but not a variance.
Okay. Well, I guess what I'm hearing is it's a two-step process. First, we're going to hear some testimony information provided by
I think counsel for
town.
For both sides are going to speak to you about whether or not this is an appropriate request for variance.
Venue for the we don't have jurisdiction or we do, and then we'll make that decision whether we have that decision jurisdiction. If we do, then we'll hear it as a regular case, and if we don't,
then we're
leaving it. Okay. All right.
One thing I would mention, by the way, thanks for having us today, is you could also, depending upon what you hear in the argument from the attorneys as to this jurisdictional question, if you're not certain about how you should rule on that, and if you believe that there could be some relevance as it relates to the evidentiary side pertaining to whether you do or do not have jurisdiction, you could defer the decision on the jurisdictional question till after you've heard the evidence on the actual variance application. Decide both at the end, but that's within your discretion.
Okay. I think I'll go with the jurisdiction question first.
Sure. And by the way, I'm Ray DiGiuseppe. I'm here on behalf of the applicant, the Jeanettes, and I've got some. I think the way we would approach this for purposes of the jurisdictional question is, it's not going to be evidence. It's really going to be providing some copies of the relevant ordinances and provisions of law that go to these legal questions as opposed to factual ones. And I have on that some information to hand out. Enough copies, I think, for everyone, including Mr. Richardson.
Okay. Has he seen this before?
No.
This is new to he as well.
These are just all matters of public record in terms of sections of the UDO and whatnot.
Okay.
This is going to the jurisdictional issue?
Jurisdiction.
Thank you.
Well, I appreciate your time. Again, it's an interesting question. I agree. I've been doing municipal law for quite some time myself, and I've not run into it myself. And I think there are two aspects to this jurisdictional question. One is one that I've already gone over to some extent with Mr. Richardson in the past, but then the other is one that came up when we had a meeting with Mr. Satterfield. And that's the one question I think we probably would start with, and that is that does the Board of Adjustment have the power to act at all? Because we're talking about a parking plan that was adopted and implemented by the town council. And then the second question would be, if it has the power to do so, whether it could grant a variance to the Jeanettes, even though the property that's at issue is property not owned by the Jeanettes and instead is town property, or at least within a right-of-way easement that the town has. Those are the two big questions I think we have to try to answer. I've gone through what I could with what I could find that's deemed relevant as to this issue. I mean, to me, I think a good place to start is where you have in your package there the purpose of the powers and duties of the Board of Adjustment, what its designed to do, and referencing the provisions of law and the ordinance that dictate its powers and duties. That's there in 2.4 in terms of how it's described as having powers and duties that are dictated by the town code, the ordinance in 160D. And if we move on from there to the variance section, which is 2.14D, that should be the next thing in your packet. The concept of what the Board of Adjustment would do in a variance context can help us answer the first question, inform that at least, as to whether it has the power to act in the context of an ordinance per se or a parking plan that's adopted and implemented by the town council, not the body that we're before us, I'm before right now. And I think 2.14 is helpful in informing that by looking at section 3A and considering that what it says is what the Board of Adjustment is doing there is assessing for the unreasonable hardships as may apply to citizens who seek a variance from a strict application of the ordinance. Refers to whatever an ordinance means. I think understanding then what an ordinance is for purposes of the Board of Adjustment's power and what it can do, we can look further into the other statutes, which again are all public record statutes that are behind the scenes in all of these contexts. 160A77 is a place to start too, where it talks about the code of ordinances generally and how the town council in a given municipality can codify ordinances into certain classes or classifications. One classification of an ordinance, which again is referenced in 2.14, it's the section we just saw, the UDO, is the designation of regulations applied to parking. Broadly speaking, then, ordinance for purposes of the UDO, I think, should be interpreted to include regulations on parking, as we can see, informed by 160A77. Similarly, I have cited 160D102, some definitional sections. And in particular, the second page of that document, number 14, refers to what is the meaning of a developmental regulation. And that's also an inclusive term, UDO, ordinance, or zoning regulation, a subdivision regulation. And we move to 160D302, the next document, boards of adjustments, stating that boards generally hear and decide all matters upon which it is required to pass under any statute or developmental regulation. Which developmental regulation includes ordinances and zoning regulations, as we can see in the other statutes, including the next page, 160D701, which is 160D, as we know, is the specific statutory scheme that applies to boards of adjustment. And so in here, in this context as well, we see zoning regulations being specifically referenced. Zoning regulations are also part of the general definition of the development ordinance and ordinance and the other statutes in terms of what it is that boards of adjustment are looking at in terms of power. And if you think about it, generally speaking, all ordinances are acts of essentially the town council. They all are that because they're the legislative body of the town. So anything that is adjudicated, defined, implemented, enacted by the town council is an ordinance in that sense. If that were not the case, then the Board of Adjustment wouldn't be doing, it couldn't act in any case because all acts that the board is looking at, all subject matters that come before this board for purposes of seeking variances from the application of something is an ordinance or a regulation that's been adopted by the town council. That's just how it is. That's what you're looking at always when you're trying to decide whether to grant a variance. You're looking at the ordinance, and the real question is whether this parking plan, which is affecting them in a certain way, is an ordinance in that sense from which this board can grant a variance and is empowered to do so under the general criteria for granting variances. Again, I'm more on the first question yet of whether you have the power to act generally, even though we're talking about a parking plan adopted by the town. I bring it up because we talked about it with Mr. Satterfield, and he had some concerns about that issue, independent of the question about who owns the property at issue. So I wanted to address it. I think that the Board of Adjustment does have the power and is not precluded from rendering a decision in this context simply because it was a parking plan adopted and implemented by the town, because that is nothing more than essentially an ordinance, and you all are empowered to consider the impact of an ordinance on a resident who comes to you seeking relief from that impact. I think the first question is resolved properly to conclude that you do have the power to act. The second question is the one about, well, if you do have the power to act, can you do so with respect to property that's not owned by the Jeanettes? And I had gone through a fair amount of discussion with Mr. Richardson about that as well. And we had some case law citations back and forth on that question. My read of all the case law, which I had shared with him, and is also a matter of public record, is that when we're talking about the standing of an individual seek relief, the impact of an ordinance, the standing emanates not from that person's ownership of the property at issue, but instead from the impact of that ordinance on that person's ownership rights and interests. That's how the case law defines it. I had provided for Mr. Richardson previously, for example, in the case of Gardner versus Richmond County, that's 911 SE 2nd 761, that in the context of a declaratory judgment act, for example, any citizen would have the right to challenge the application of an ordinance to them merely because of the manner in which it affects them in terms of its validity and its impact on them. It does not hinge on whether the person owns the property. Just the same that I've seen case law illustrations and examples, which again I already provided to Mr. Richardson, that specifically refer to contexts in which people are seeking relief from the application of an ordinance as to property that's adjoining to them, not owned by them, but adjoining to them, because the impact of an ordinance as it relates to this neighboring property has an impact on them in such a way that they can seek relief statutorily from that application of the ordinance. I think that there is standing for the Jeanettes to be able to come to this board and seek relief in the form of a variance for those reasons. If they have standing to facially challenge the ordinance itself as invalid in any number of ways in a court of law, I don't see how they could not have standing to challenge the application of an ordinance in the context of a variance. When I say challenge, I mean what you're looking at is more sort of like an as-applied circumstance, where you're not necessarily saying that the ordinance itself is facially invalid and should be struck in all manners. What you're saying is that in this particular instance, as applied to me, it's creating an unnecessary hardship. And I'm coming to you to seek relief from that. You can give me that relief because you have the power to alter the application of ordinances that otherwise apply. And I can meet the criteria, which is what we would do if we move to the evidentiary side, for a variance, if you allow me to show that I can, because I've met all those.
Thanks.
That's the basic position.
I'll hear from Mr. Richardson now.
Thank you, Mr. Chairman, members of the board. The Jeanettes have filed for a variance of property they do not own. That is not appropriate. That is not allowed. Everything that Mr. DiGiuseppe just said to you may be true, but it has to first have a proper application to the board per the UDO 2.12 subparagraph A, number 2. Applications for development approvals may be made by the landowner, a lessee, or person holding an option or contract to purchase or lease land, or an authorized agent of the landowner. The town has never authorized the Jeanettes or anyone else to pursue a variance before this board of town-owned property that's in question. So that basis in and of itself warrants dismissal of this appeal. I do have a few other items. May I approach?
I got a copy for the man here. Okay.
What I've gathered for you is the variance submission that was filled out by the Jeanettes, signature of the applicant. Okay. Now, when staff receives a variance application, they're not authorized to refuse it. They have to take it, and then it has to get scheduled for an appeal. I mean, before the board, not an appeal, but for a variance hearing. If you go to the next page, it talks about the completed application, Board of Adjustment, and decision rendered. Everything under the statute governing variances is from the perspective of the landowner is seeking to show this board sufficient grounds that a hardship exists that meets the four criteria for granting of a variance. Again, you have to be the agent of the owner, the applicant for the owner, or the owner itself. That doesn't exist here. As we go further on, you'll see on the application, it says applicant's signature and owner's signature of the property in question for which the variance is sought. The Jeanettes have filled out both applicant's signature and owner's signature, but they're neither one of those for the town of Sunset Beach's property. I've then gone through and attached some treatises from, again, the UNC School of Government, Coates Canons, it's well known, Adam Lovelady. Everything in here I've gone and taken the trouble of having it highlighted, referring to hardships, an unnecessary hardship for the owner. Next page, a property owner can prove unnecessary hardship. Down further, a variance may be appropriate if the owner presents evidence to show she meets all the standards. Next page, the hardship must not result from actions taken by the applicant or property owner. The town is neither of those before you today. As you continue on in the materials, you'll come to the general statute that lays out the variances, and on the last page of 160D-705, the standards for variances, you'll see D3, the hardship did not result from actions taken by the applicant or the property owner. The the town of Sunset Beach is neither the applicant nor the property owner. The next Coates Canon treatise, as you go further into that one, talks about a case, and it's highlighted, talking about the Williams Standard, focuses on the use that the property owner actually wishes to make of the property. In contrast, the no reasonable use or reasonable return implies that the property owner must also show that other alternative uses of property are unreasonable. Again, the point of this is the entire premise of a variance that's sought is from the perspective and the application of the property owner or the applicant that's authorized by the property owner. We have none of that here today. And for that reason, the Jeanettes application for a variance should be dismissed for this board lacking subject matter jurisdiction to consider it. I'm not in the business of giving adversaries or opposing parties legal advice. This is not the appropriate path for the Jeanettes if they feel that they have a grievance to take up. It's not before this Board of Adjustment. And I would ask that the board dismiss this application for hearing on the basis of a lack of subject matter jurisdiction. Thank you.
Okay.
Just make a couple comments.
Quickly.
Okay. I just would point out, I think he's interpreting applicant or the property owner a little bit too liberally for purposes of his position, in that the applicant or the owner, the use of the disjunctive term doesn't tell us by itself that means that the applicant has to be a a representative of the owner. It just says it's the applicant or the property owner. And under 2.14D2, I had highlighted some language in there where it says that I highlighted if the owner did not initiate the hearing. So the context of D2 itself allows for the possibility that it's not always the owner, or not necessarily the owner, who initiates or applies for the variance. The criteria of the variance itself don't require that. Again, with the ability of a person to challenge the ordinance facially, by even not being the owner of the property, it seems to me that it follows that they would have standing in a much more limited way to seek relief from the way that an ordinance affects them on adjoining property. And another thing is that when we're talking about the owner of the property as it relates to this issue, the owner issue, it's not like we're talking about this building, the building that is exclusively for the use of the town and can exclude the public from it. We're talking about an area of roadway which is open to the public and is really more of a public right of way. The Jeanettes have the right of access to it like anybody else who wants to park there from the public. The town maintains it, but more so in the way of a public right of way. It's not something over which they exercise exclusive control. I think that makes it, leans more in favor of a conclusion that there is a means by which a person such as Mr. Jeanette would be able to seek relief from this board. And to Mr., I know what he's getting at, what he's saying, Mr. Richardson. I can't give legal advice about what avenue to go. There are really no other avenues to go in the sense of looking for some kind of relief, because the only other body that could act is the town council, and it's entirely within their discretion whether to take any action. But I'm not conceding that this isn't a proper method. I think that is I think it's a reasonable interpretation of the UDO, the law. But I understand where you're at.
All right, thanks. Okay, so Jerry, we've heard from both. We're going to deliberate on whether or not we feel we have jurisdiction to make that call. Okay?
That would be appropriate, and
All right.
and I think your vote would be majority.
All right, okay. I'll ask you start with me, if you would, Bruce. What do you think?
I tend to agree that they are not the ones who don't have the right to dictate what the town does on the town's property. We may not like it, as in the last case, it may be questionable, but it is not an issue for the adjacent landowner. So I don't see standing.
Or jurisdiction for us, is what you're saying. I'll try with you, Bruce.
I agree. I think to give a variance, you have to give a variance towards the owner, and at this point, we're not doing that. That hasn't been explained.
Aaron,
Well, it's my understanding that if it's the owner, we can give
Yeah,
a variance,
okay.
but if it's not, and they don't own that property.
Okay.
I concur. He's not the owner, so.
You raised some great points here, but I agree. I don't think we have the jurisdiction to handle this. I think it belongs with the council or a different board. It's out of our jurisdiction. So I would ask that we now vote on on confirming that we do not have jurisdiction for this, and I'll take an aye from each of you. Or not?
Aye.
Aye.
Aye as well. So that's unanimous. We feel like we don't have the jurisdiction, so it's a shame, but I don't think we can hear this.
Maybe a different avenue.
Yes, understood.
I'm sorry.
I think we need to make a motion.
Oh,
To
okay.
dismiss for lack of subject matter jurisdiction.
You're right. Okay. So
I'll make the motion.
you'll
To
make a
dismiss
motion to dismiss
For lack of subject jurisdiction.
lack of jurisdiction.
I'll second.
And now we'll take a vote on that. Do you agree with this motion?
Aye.
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 Aye. Now it's unanimous. So we've dismissed the case then too. Okay.
Thank you.
That was the case. People on Main Street could bring the our board and we can address that, but
Gotta go back. Sorry, guys, we're not finished. We have an agenda item yet we have to deal with.
I lost that.
Where is the agenda? I lost it. I see your agenda. I have so much other paper here, I put it underneath one of the other things. Yeah, here it is. I
My
got it.
understanding,
Okay.
y'all, you still have business to wrap up for this meeting.
I have, yeah, please, hold down. Please hold it down a little bit, please. Yeah, we have one more at least administrative item to take care of, I believe. The chair for the Board of Adjustment has resigned due to health issues. And I'm sitting here because I was appointed the vice chair last meeting. So I think we need to officially do something about a chair and a vice chair in this meeting. So do I have any nominations for the chair?
I nominate you.
I nominate you.
Is there a second?
Second.
Should we vote on it?
Sure.
Aye.
Aye.
Okay, I'll take the chair. We also need a nomination for the vice chair, just in case the chair is not able to take the meeting. So we'll have a nomination for a vice chair.
I think you'd be a great one.
You.
No,
Not me.
not me. I'm going to come up on end of term here.
Oh, really?
How about you, Bruce?
I think you, Bruce. I think it's you.
Oh, Jay. Sorry.
I'm sorry. Yeah, yeah.
All right.
Go ahead.
Yeah, is it?
Sure. I got
All
another
right.
year or so.
All right, I'll second that motion then. He moved.
Yep.
I'll second. We'll vote on making Jay the vice chair.
Aye.
All in favor? Aye.
Right.
Good. All right, that's taken care of.
Very good.
All right, so I need a motion to adjourn the meeting.
I move to adjourn the meeting.
All right, second.
Second. All in favor?
All right.
We're adjourned.